Welcome, and thank you for joining us for our webinar today, Honoring Women's Health Month, Impactful Legal Developments Affecting Women in the Labor, Employment, and Benefits Space, presented by Quarles. I'm Lindsey Davis, a partner in Quarles' Milwaukee office. I work on advising and assisting employers on a broad range of labor and employment issues. Today, I am joined by my wonderful colleague, Sise, an employee benefits partner in Quarles' St. Louis office, whom you will hear from shortly. We'll begin the presentation as soon as we cover just a few logistical items. All comments in today's webinar are off the record and not for publication. All attendees are in listen-only mode, but we do welcome your questions via the Q&A box that's located below the slides in the webinar dashboard. If we don't have time to answer all questions during the webinar, we will follow up over email. Quarles is happy to be able to provide CLE credit in most U.S. jurisdictions for Quarles webinars. As of April of 2024, the American Bar Association applications, attendance submission, and certificate of attendance for our external webinars. We have updated procedures for tracking attendance for CLE credit. They include that you must be logged in, participating from your own device, and need to be actively watching the entire webinar. Please watch for pop-up polls with audio notification that will appear at several random times during the webinar. You must click on the pop-up polls to verify your attendance. Regulators require attendance to be verified, and this procedure meets that requirement. Please take a moment to review the resources box below the video feed where you'll find a copy of today's presentation, a survey link to share your feedback, and CLE application information. You can access closed captioning during the live webinar by clicking on the CC icon in the lower right-hand corner of the video player. Today's webinar is being recorded. All registrants will receive the on-demand link within a few days. And with that, we will get started. Sarah and I have a pretty robust agenda of topics we'd like to cover today. I'm going to start off by talking through employer obligations toward pregnant and nursing women under federal law. We will spend some time talking through the relatively new Pregnant Workers Fairness Act, what it requires, recent updates relating to the Pregnant Workers Fairness Act, and then we'll move into a discussion of what's called the Providing Urgent Maternal Protections for Nursing Mothers Act, known as the PUMP Act. Again, we'll cover the requirements of that act, and then we'll wrap up with walking through the interplay between these two new laws and the already existing federal laws that you've been dealing with. Then I will flip it over to Sarah, who's going to cover a number of topics in the employee benefits space, including coverage of women's preventative health care, family planning benefits, menstrual care products, reducing the stigma, and where are employer-provided benefits heading. We welcome you to submit questions, as I mentioned at the outset, and we'll take any questions as time permits at the end of today's presentation. So with that, let's dive into the Pregnant Workers Fairness Act. We are actually coming up on about the one-year anniversary of the passing of this act, which took effect on June 27th of 2023. And the Pregnant Workers Fairness Act requires employers to provide reasonable accommodations to qualified employees for known limitations relating to pregnancy, childbirth, and related medical conditions. And employers are required to provide those reasonable accommodations unless doing so would create an undue hardship. I'm going to break down each of the key elements of the Pregnant Workers Fairness Act so you can further understand when your obligations may be triggered. First, with respect to a reasonable accommodation, that is essentially a modification or adjustment to a job or work environment that enables a pregnant employee the equal opportunity to successfully perform in their job. And the PWFA gives us many examples of the types of things that would likely constitute reasonable accommodations. And these include simple things like providing employees the ability to sit, to drink water, to access closer parking. They may require flexibility in work hours, the provision of appropriately sized uniforms, additional break time for eating or using the restroom or resting, the use of leave to recover from childbirth, and excusal from strenuous activities. That's not an exhaustive list of reasonable accommodations, but just examples that are provided to assist employers in understanding the types of accommodations they may be required to provide. Remember that reasonable accommodations are available to qualified employees, and that's a concept that's probably familiar to most of you because you've dealt with the Americans with Disabilities Act before. Under the PWFA, a qualified employee is an employee who's able to perform the essential functions of their job, except that an employee or applicant is considered qualified even if they have an inability to perform an essential function that is temporary, and that inability to perform an essential function can be reasonably accommodated. So this is actually a very key difference between the PWFA and the Americans with Disabilities Act, because you probably know that under the ADA, qualified individuals are only those who can perform all essential functions with or without a reasonable accommodation. Here, we're saying that there may be instances in which a pregnant employee cannot perform some of their essential functions, but as long as that's temporary, and as long as we can accommodate that, that individual will still be considered a qualified employee. And what we know under guidance that we've received relating to the PWFA is this temporary period for which an employee cannot perform an essential function can be as long as 40 weeks, right? Essentially covering the entire duration of the pregnancy. All right, let's talk about known limitations, because again, the obligation is to provide reasonable accommodations to qualified individuals with known limitations. So under the PWFA, a known limitation is a physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions, which is communicated to the employer. Keep in mind that a known limitation under the PWFA does not have to meet the definition of a disability under the ADA. So this means that there are going to be circumstances in which we have to provide reasonable accommodations, even though a pregnant employee's limitations don't hit that higher threshold of constituting a disability under the ADA. Okay, and lastly, we have to provide reasonable accommodations unless doing so would create an undue hardship to the employer. And here, the analysis is similar as under the ADA. So we are going to look at factors like whether providing the accommodation would result in excessive cost, requires substantial scope, or would result in a major disruption to the business operations of the employer. Okay, so those are the basics. Let's talk next about some recent developments with respect to the PWFA. So just about a month ago today, the EEOC issued its final regulations relating to the Pregnant Workers Fairness Act. And those are currently slated to take effect about a month from today on June 18th of 2024. At the same time that the EEOC issued its regulations, it also provided a summary of key provisions and interpretive guidance. Those resources are available on the EEOC's website, and I encourage employers and HR representatives who are going to be facilitating the accommodations process under the PWFA to take a look at those additional resources as well. Today, we'll talk about what I would say are the 4 key takeaways that we have gotten from the regulations and additional guidance that came through. Briefly, but I'll dive deeper into each. The 4 big takeaways from my perspective are that the EEOC is making clear it broadly interprets pregnancy, childbirth, or related medical conditions. The next thing that comes out of the regulations and is key is that there's no magic words or precise processes that employees can be required to follow in order to request an accommodation. This means that HR representatives and supervisors have to really be ears wide open and looking for those situations where accommodation obligations may be triggered. The EEOC is also going to presume that certain predictable accommodations are per se reasonable and do not impose an undue hardship, which basically means there are sort of basic accommodations we have to put in place for all pregnant employees. And you're not really going to be able to make the argument that those basic accommodations are unreasonable or too difficult for an employer to undertake. Employers are also restricted in whether and what supporting documentation they may request, and this makes the PWFA a bit different than the ADA. So we'll talk about that a bit more specifically as well. So having previewed them, let's kind of dive into those 4 key takeaways one by one. As I said, the first big takeaway is that the EEOC is broadly interpreting what constitutes pregnancy, childbirth, or related medical conditions. Under the regulations, there's a non-exhaustive list of conditions that can give rise to a request for accommodation, and you'll see on the slide that there are many. They include current pregnancy, whether it's a complicated or uncomplicated pregnancy, past pregnancy, potential or intended pregnancy, things like infertility, fertility treatment, and the use of contraception, labor and childbirth, the termination of pregnancy, for example, miscarriages or abortions, and numerous pregnancy-related conditions. Again, things like gestational diabetes, preeclampsia, endometriosis, on and on the list goes. So you can see that the EEOC is conveying it's going to broadly construe who is covered and entitled to reasonable accommodations under the PWFA. And this, of course, has caused some drama, okay? So this broad interpretation, and specifically the inclusion of abortion as a related medical condition, has resulted already in numerous legal challenges. This includes a lawsuit brought by 17 state attorneys generals alleging that the EEOC's enforcement of abortion-related workplace accommodations is unconstitutional. There was also a lawsuit in a Texas federal district court that has actually already resulted in an injunction being issued, which prevents federal agencies from enforcing the Pregnant Workers Fairness Act against the state of Texas and its divisions and agencies. Importantly, that injunction does not extend to private employers in the state of Texas, and it has already been appealed by the EEOC to the Fifth Circuit Court of Appeals. So there are legal challenges surrounding the regulations that we all need to keep an eye on. Right now, except for that smaller subset of employers in Texas, the law and its regulations appear that they will be enforceable as written, but we need to keep an eye in particular on that lawsuit recently brought by 17 state attorneys generals. Okay, the second key takeaway here is that there's no magic words or precise processes that are required for an employee to request an accommodation. And the guidance and information we received last month indicates that even simple exchanges of information will be enough to trigger an employer's accommodation obligations under the PWFA. So things like, I'm having trouble getting to work at my scheduled time because I have morning sickness, or I need more bathroom breaks because of my pregnancy, or I need time off from work to attend a medical appointment because of my pregnancy. It's not necessary for an employee to specifically reference the PWFA or to use the phrase reasonable accommodation in order for an employer's obligations to be triggered. So be careful, make sure your supervisors and HR personnel are trained to be listening for situations in which a pregnant employee may need some type of accommodation, such as additional break time or flexibility in their schedule. Okay, key takeaway number 3, the EEOC is going to presume that certain predictable accommodations are reasonable and do not impose an undue hardship. And the regulations give us 4 situations in which both of those things will be true, right? So those situations are allowing an employee to carry or keep water nearby and drink it, allowing an employee to take additional restroom breaks as needed, allowing an employee whose work requires standing to sit and whose work requires sitting to stand as needed, and allowing an employee to take breaks to eat and drink as needed, right? If any of those 4 situations come up, the EEOC is telling us those are reasonable requests. Employer, don't come to us and try to tell us that these are going to impose an undue hardship on you. The expectation per the EEOC is that these requests be kind of granted of hand, right? Now, we'll talk a little bit later about whether there might be any exceptions to any of these requirements for smaller employers. But generally speaking, if you're getting requests for these types of things from a pregnant employee or an employee with a pregnancy-related medical condition, you're going to want to grant them, okay? And the last key takeaway here from my perspective is you've got to be careful about whether and when you're requesting supporting documentation for accommodation requests under this law. The general rule under the PWFA is that employers can seek supporting medical documentation as long as it's reasonable under the circumstances. But there are a couple of sort of key big picture points that kind of carve out that general rule. The first is employers are only permitted to request the minimum reasonable documentation that is sufficient to confirm the physical or mental condition underlying the employee's limitation, right? So you can ask for a doctor's note verifying that the employee is pregnant or has a pregnancy-related medical condition, but you're not going to be able to require healthcare providers to complete the sort of more extensive medical questionnaire you may have done in an ADA situation, unless the ADA also applies. There are also certain situations in which employers cannot seek supporting documentation. The regulations provide that employers should not be requesting documentation if what's going on is the limitation and need for accommodation are obvious, right? Think of an employee who's 8 months pregnant, clearly has that sort of pregnant belly, and is asking to be able to sit or stand periodically as needed, right? That need for accommodation and limitation are fairly obvious, and it's not going to be a situation in which you're going to want to request documentation. If you already have sufficient information, the regulations tell us, shut it down, don't ask for more, okay? You don't want to go further and further down the documentation road that's going to cause you problems. If the request is for one of those 4 predictable accommodations we talked about, the regulations are telling us you should not be seeking supporting documentation, right? You basically need to be letting people, pregnant people or people with pregnancy-related conditions, drink that water, take those restroom breaks, take breaks to have a snack as needed. If the request is for a lactation accommodation, the PWFA says you should not be seeking supporting documentation for that. And lastly, if you've got a situation in which this is an accommodation that is made available without documentation for other employees who are seeking it for a non-PWFA reason, you don't want to be requesting documentation only from your pregnant employees, right? So if you have a general workplace rule that says, hey, if you need to run and use the restroom, you don't need permission from us, and you let everyone sort of follow that rule, you don't want to be doing something differently or requesting documentation from only your pregnant employees in order for them to do that same thing, okay? So that covers the Pregnant Workers Fairness Act. The next act that I want to talk with and spend a couple of minutes on is the PUMP Act. This one became effective on December 29th of 2022 and basically amended the Fair Labor Standards Act and expanded the requirement for providing reasonable break time and a private space to express breast milk to all nursing employees for 1 year after the birth of the child. The other thing the PUMP Act did was expand employees' options to enforce these requirements. So now, employees must generally first inform the employer if they think the employer is not providing break time in a private space, and allow the employer 10 calendar days to get in compliance. But once that has occurred, the employee can now bring a complaint against the employer with the Department of Labor, or go straight into federal court and bring a lawsuit against the employer. That notice requirement and the 10 days to cure is not required if an employee has been discharged because of a request for lactation space or break time, or if an employer makes it clear that they will not comply with the PUMP Act. Then you don't have to wait 10 days. You can go straight to bringing a complaint or lawsuit. Okay, gonna break it down once more. What are the requirements under the PUMP Act? First thing is we've got to provide reasonable break time. And the PUMP Act says that employees can take a reasonably long break each time they need to express breast milk for up to 1 year after the child's birth. This means we can't have a rule that says you get to do it 3 times a day and that's it, right? It's really driven by the employee and the employee's needs, and we've got to provide that reasonable break time each time it's requested. And when an employee goes on a reasonable lactation break, they have to be completely relieved from their responsibilities, or they have to be paid for the break time. The second requirement is that employers provide a private space. This can never be a bathroom. It essentially needs to be a functional space for expressing breast milk that's shielded from view and free from intrusion. So if the room has windows, it needs to have blinds. Presumably the room will have a door, and that door needs to have a lock. The room should have an outlet if the woman is using a breast pump. It essentially needs to have the basics that a woman would need in order to be able to pump breast milk. Employees who are remote workers or telework are also permitted to take pump breaks on the same basis as in-office employees. Of course, in that circumstance, it's the employee's obligation to provide the appropriate space for doing so, but they do get to take breaks and they should be relieved from duty or compensated for their break time. Okay. I mentioned previously that for one of these 2 laws, at least, there is a undue hardship exception. And this is an exception that applies to small employers only. Essentially, employers with fewer than 50 employees are not subject to the break time and space requirements if providing them would impose an undue hardship. To determine if you have if you meet the 50 employee threshold, you have to count all employees regardless of their location. So if you are a company that has, let's say 5 locations, each of the 5 locations has 10 employees, then you're at 50 employees, right? So you've got to look across all of your locations. And in making the determination about whether providing the break time and space will result in an undue hardship, the factors you should be considering are the size of the business, the financial resources of the business, and the nature and structure of the employer's business. Okay. With that, I'm going to wrap up my portion of today by just briefly touching on the interplay between these 2 laws and the other laws that we know are out there and may obligate employers to provide certain accommodations to pregnant employees and employees with pregnancy-related conditions. So The PWFA and the Pump Act were essentially intended to fill gaps that were existing in the laws that we already have in place. But the reality is, and what the picture is meant to convey, is that there is a lot of intersection and overlap amongst these laws, right? So you have Title VII that prohibits discrimination on the basis of sex, including pregnancy. We have the ADA that prohibits discrimination on the basis of a disability and requires employers to provide reasonable accommodations. And then we have the FMLA that requires employers to provide leave to employees for their own serious health condition, the serious health condition of an immediate family member, and for pregnancy, birth, and baby bonding. And you have to bear in mind that these different laws may be triggered at the same time or at various times throughout the process of working with a pregnant employee. And there are key differences amongst them, right? So we talked about some of those today. The documentation, for instance, that you can request is very different under the PWFA and the ADA. Arguably now, milder conditions are covered under the PWFA that would not have been covered under the ADA. Under the PWFA, you can't force an employee to take a leave of absence. That's supposed to be an accommodation of last resort if there are no others that are available that won't pose an undue hardship. But leave can come up, and when it does, leave provided under the PWFA should also run concurrent with the FMLA, assuming that the employee does have a serious health condition, that the leave is pregnancy related, or is for receiving prenatal care, right? So you have to be thinking about, what do I have to do under the PWFA, but does this also implicate the ADA or the FMLA? And don't assume that once an employee has taken 12 weeks of leave, for instance, under the FMLA, that they aren't entitled to any more leave, right? They may be entitled to additional leave under the PWFA or under the ADA, depending on the circumstances. So you have to have sort of your core team that's responsible for engaging in the interactive process and determining accommodations. Make sure they're aware of their obligations under each of these various laws. And then don't forget about state law as well. Both the PWFA and the Pump Act do not preempt state or local laws that provide greater pregnancy-related protections for employees. So you can think of these laws as setting sort of the minimum requirements, but in a lot of states, you may be required to do even more. So with that, I will turn it over to Sarah, who has many interesting topics in the employee benefits space that she's going to cover with us. Sarah, over to you.
Thanks, Lindsay. As we shift to talk about issues affecting women in the benefits space, I thought we'd start with the Affordable Care Act. The Affordable Care Act has been in place since 2010, so 14 years, but developments continue, I won't say daily, but certainly monthly. In doing this research, just as an aside, I found an article that said there have been over 2,000 cases filed to litigate issues under the Affordable Care Act, so I don't think things are going to slow down in the next 14 years. So let's start with a preventive care mandate. Employer-provided health plans and insured plans made available either in the individual market or on the market exchange are required to cover preventive care at $1. This means that no deductibles, coinsurance, copays, or other out-of-pocket costs can be applied for individuals seeking and receiving this preventive care. The change has been, in fact, impactful to medical care for all individuals, but in particular women. The list on this slide lists some of the items that are considered preventive care. And I wanted to highlight just a few. I'm going to talk a little bit more about the breastfeeding support and supplies that are covered under this mandate, get into a little about the contraceptive coverage and some of the challenges to that coverage, that have resulted in birth control not being available for all women with no cost. And then also some of the cancer-related items. So who creates this list? Who creates all of the services that are included as preventive under the ACA? It's created by members of the U.S. Preventive Services Task Force, the Advisory Committee on Immunization Practices, and the Health Resources and Services Administration. And I bring that up because it's going to be important when we talk about a currently pending challenge to some of the items included on the preventive services mandate list. Once these three organizations issue their guidance, it's typically followed by guidance from the Department of Labor, HHS, and the IRS to tell us what that means for ACA healthcare plans. For example, when breast screening and genetic testing was added to the list, we got some guidance from these government agencies to say if a woman does have a positive result on one of these tests, they should receive appropriate medical care following that, also at no cost. In addition, individuals who need chemo preventive medication, such as tamoxifen or raloxifene, because they're at an increased risk for breast cancer, can receive that chemo medication as a preventive service with no cost sharing. So what has the impact of this law and the preventive services mandate had since the enactment in 2014? I thought that the impact would be obvious. Covering these at no cost might encourage people to get tests and to seek services that they might not otherwise seek due to the cost barrier. But the research and the studies have found that while some health outcomes have been impacted, some have also remained flat. So that was definitely surprising to me. One of the things that the research has found, which wasn't surprising, is that the cost to women for contraception has significantly decreased. And most importantly, that's including both oral contraceptives, which was more the norm before the passage of the ACA as a contraceptive of choice. And now we have more women using long-acting reversible contraceptives like IUDs because the cost is now covered at $1. We'll get into this a little more, but there are exceptions that apply to this coverage mandate, which have not brought the cost down to zero for all women. The studies related to the effect of the ACA on contraception also suggest that the use of the long-ranging contraception has increased since the passage of the ACA, and the studies link it to not only lower out-of-pocket costs, but improved use and adherence to the prescription birth control. I also found a study by the National Institutes for Health from 2018, which showed that coverage of breastfeeding supplies and counseling at no cost has increased the duration of time that nursing mothers nurse by more than 10%. The interpretation of the breastfeeding mandate coverage continues to evolve. Originally, the mandate was interpreted to mean that plans only had to cover items such as manual pumps, but recent guidance that was effective in 2023 provides that double electric pumps are required to be covered at this time. We still have a lot of debate going on about what supplies mean in the breastfeeding mandate. So you can imagine a lot of supplies, replacement parts, and other items are needed to run a breast pump. So there's still some debate about whether those should be covered with no cost sharing. I thought it might be interesting to talk about some of the legal challenges. I said issues on the slide. Some of the legal challenges to implementation of the preventive services mandate. The first one relates to religious objections to coverage of birth control and the accommodation process that was originally in place when the ACA was passed. Health plans sponsored by religious employers, churches, and houses of worship do not have to cover contraceptive methods and counseling. This was part of the original law. Some nonprofit religious organizations currently also do not have to offer this coverage. They also don't have to contract, arrange, or pay for the contraceptive coverage. For these types of employers, the original law and regulations set up a process by which the third-party administrator, the TPA, or the insurer for the plan would make the coverage available without cost to the religious employer. And then they could seek reimbursement through other means from HHS. In 2014, in the Hobby Lobby case, the Supreme Court decided that the Religious Freedom Restoration Act protected for-profit employers from having to provide this coverage. The same accommodation process became available to those entities if they wanted to not provide the coverage. After the Hobby Lobby case, there were additional challenges to the law that challenged the accommodation process itself, saying just having to go through the accommodation process violated not only the Constitution, but the RFRA, the Religious Freedom Restoration Act. Under the Trump administration, a rule was passed which allowed for exemptions to this coverage for moral or religious reasons. These exemptions apply to any employer that objects to, and I'm just quoting the rule, establishing, maintaining, providing, offering, or arranging for coverage or payments for some or all contraceptive services, if that was based on sincerely held religious beliefs. So under these rules, the key point too, not only did this apply to for-profit entities, including publicly traded companies, but the accommodation became optional. So if an organization had these sincerely held religious beliefs, did not want to offer this contraceptive coverage, they could do so without providing the original accommodation, meaning that women had to pay for the contraceptive prescription drugs or services. This rule withstood challenges all the way up to the Supreme Court in the Little Sisters of the Poor case. Not surprisingly, the Biden administration is changing the rule. So the rules under the new proposed rules, which are not final yet, the accommodation process would be reintroduced. And under that, women could, through the accommodation, still obtain the contraception drugs and services with no cost sharing. So I don't know about you, it's easy to get whiplash trying to figure out where the law is in this area. But that's hopefully an indication of where we are today. There's also litigation currently challenging more of the core of the preventive services mandate. That case is Braidwood Management versus Becerra. So the U.S. District Court in the Northern District of Texas decided that the mandate cannot apply to preventive services added after the ACA was originally enacted. There's a lot of technical reasons for this, but going back to the issue we talked about before, there are 3 organizations that pass these preventive services mandates. And the district court made the decision that that wasn't a proper process to add additional items to the list after 2010. So for example, if a method of birth control did not exist in 2010 or wasn't on the list, and it now is, it would not be covered at $1 under the district court's holding. So the Fifth Circuit is reviewing the case. It granted a stay to the Department of Health and Human Services so that the preventative services mandate, including items that have been added to the list after 2010, can currently be enforced until the Fifth Circuit makes its decision on the case. Another area of employee benefits law that affects women and men is the area of family planning benefits. Contraception, infertility treatment, and coverage for other reproductive health services can fall into this category. So one thing I looked at when I started to put this presentation together was, what is the cost of IVF? And interestingly, based on a Forbes Health article from 2023, a single IVF cycle, which is usually defined as ovarian stimulation, egg retrieval, and embryo transfer, can range from $15,000 to $30,000, depending on where the procedure is performed and the amount of medication that the woman needs for the cycle. Medications can account for up to 35% of the charges. So this is for one cycle of infertility treatment, but I'm sure as individuals who've gone through this process can help us understand, sometimes more than one cycle of treatment is needed in order to have a successful pregnancy. So the current landscape under the tax law is kind of interesting. It's evolving, but not really as rapidly as I would expect. As a result, fertility treatment can result in inequitable tax treatment depending on the family makeup and specific circumstances of the individuals. We'll get into that a little more. So the IRS's position is to currently treat medical infertility as the touch point for whether medical expenses are deductible and therefore non-taxable when an employer provides those to an employee. In many cases, especially involving LGBTQ+ families, there may not be a diagnosis of medical infertility. Also, I've found in my experience that employers don't really want to ask about specific diagnoses. They aren't interested in requiring their employees to disclose medical diagnoses in order to determine how to tax benefits that are provided. It raises a whole host of other issues under both ERISA and HIPAA. The case law and the informal guidance from the IRS is a little more progressive. In 2021, the IRS suggested that medical expense deductions could potentially be broadened to circumstances where the taxpayer personally undergoes medical procedures for assisted reproduction despite not having that medical infertility diagnosis. But it doesn't cover third-party expenses such as IVF or gestational surrogacy if they're applied to someone else's body. So if they're applied to the employee and the employee's family and dependents, tax deductible. Applied to a surrogate or someone who's not that tax dependent, then not tax deductible. So this approach that the IRS alluded to in 2021 has not been applied to other factual scenarios. For example, we don't have any guidance from the IRS on situations involving a female same-sex couple or a single woman attempting to start a family on her own. Just one note on ERISA group health plan coverage. Typically, well, to say this differently, infertility benefits such as in vitro fertilization are not considered under the Affordable Care Act as essential health benefits. And if an item is not classified as an essential health benefit, then it's not required to be covered under an Affordable Care Act compliant plan. What that means is when it's not characterized as that essential health benefit, plans can impose annual and lifetime maximums, or they can just exclude them. So there are plans that don't cover infertility treatment, and there are also plans that have annual limits or lifetime limits. So as we mentioned before, this infertility treatments can certainly span over calendar years, and so you might bump up against that annual limitation several times, and also a lifetime limit could be imposed regardless of what calendar year the services are provided. So I wanted to spend just a little more time on surrogacy benefits. A little shocking. Based on the research that I found, the average cost of surrogacy can be between $100,000 to $200,000, depending on the process and largely on geographic area. Surrogacy is a process where parents create embryos, either using their own egg and sperm or donor sperm, donor egg and or donor sperm, and the embryo is transferred to the surrogate, who carries the pregnancy for the intended parents. Since the surrogate's not an employee, and the surrogate is presumably not a dependent or spouse of the employee, the medical treatment expenses that an employer pays are not excludable from the employee's pay, meaning they're taxable. For this reason, and also to preserve the treatment of the group health plans as ERISA plans, which can only cover employees and their dependents, coverage for the surrogate is generally not part of any ERISA group health plan. Similarly, payment or reimbursement by an employer for those expenses associated with the surrogacy process, which can include attorney's fees, court costs, fees from egg or sperm donation, surrogacy agency fees, and also compensation to the surrogate. Any of those expenses reimbursed or paid by an employer would be taxable. In a 2020 Emerging Trends in Healthcare survey from Willis Towers Watson, they reported that 9% of employers reported that they provided some kind of surrogacy reimbursement program, and another 3% anticipated doing so in 2021. So really a newer, benefit that employers are considering. But if those 3% that anticipated offering something did, were over 10% of employers offering some kind of surrogacy benefit. Many had limits on that coverage, and it usually ranged from $10,000 to $20,000, which if the other information that I mentioned is accurate, really a small cost of the overall process. I thought we'd also want to talk a little in this family planning benefits section about reproductive health services and how that affects the benefits that employers provide. And that's really the focus of what we'll talk about in the context of the Dobbs decision. So in 2022, the US Supreme Court held in Dobbs v. Jackson Women's Health Organization that the Constitution, the US Constitution, does not protect a woman's right to an abortion. As a result of this case, states may regulate whether an abortion is legal in their states. Some states have done that by protecting those services or codified in some way that individuals in that state have a right to them. And others have banned or restricted access to these services. In other states that haven't taken an affirmative action yet, there's litigation and competing legislative efforts targeted at these services. If we look at what's been happening since the Dobbs decisions with employer-provided health plans, it's interesting. So 10 states prohibit insured plans from covering abortion services. So if an employer uses an insured product to provide benefits to its employees, and that policy is issued in those 10 states, then that plan will not cover reproductive health services, including abortion. Some state laws or insurance laws as applied to an ERISA self-funded health plan are preempted. Therefore, if the same employer in that state chose to self-fund their health plan, it could cover abortion services in that state. And And Lindsey touched a little on what's going on with the Pregnancy Discrimination Act. It does contain a provision that requires coverage of abortion if the endangerment of the mother's life, and it also requires coverage of post-abortion complications, even if the abortion services are not covered. So interestingly, according to a Kaiser Family Foundation survey of large employers in 2023, so a year after the decision in Dobbs, over 40% of large employers reported not knowing what abortion services were covered under their plan. This is very in line with what I found after the Dobbs decision. It just wasn't a focal point. Pre-Dobbs, many plans followed the practice of the insurer or TPA, as they do with many other covered benefits. Post-Dobbs, there certainly became a greater awareness of what was covered. In my practice, I didn't see employers making a lot of changes to what was covered, but there was greater awareness and communication regarding what was covered under the plan. Also, since Dobbs, employers in states where these 10 states and other states where abortion services cannot be provided have looked into or adopted travel benefits for out-of-state travel. There are different mechanisms to offer that travel benefit, and certainly there are ways to do that to protect an employer, including doing so inside of an ERISA governed health plan, and finding ways to provide those travel benefits on a tax-preferred basis. There's also, in my experience, been a greater focus on what is the reach and the scope of ERISA preemption protection. For example, ERISA does not protect generally against state criminal law liability. So there are certainly issues for employers to think about in this area, but I think for today, we're just going to leave the discussion there. So another issue that I wanted to talk about today was the treatment of menstrual care products under the Tax Act. It's kind of a interesting history. So under the Internal Revenue Code, medical care paid for or provided by an employer is not taxable. The definition of medical care is amounts paid for the diagnosis, cure, mitigation, treatment, or prevention of disease, or importantly, and I added importantly, for the purpose of affecting any structure or function of the body. Interestingly though, before 2020, menstrual care products were not considered medical care. So for tax purposes, for example, they couldn't be reimbursed from a health flexible spending account, a health savings account, or a health reimbursement arrangement. The CARES Act changed the treatment of menstrual care products for purposes of those kinds of spending accounts. So the tax code that defines medical care wasn't changed, but at least for purposes of these spending accounts, it was. So women who incur expenses for menstrual care products can now get reimbursement on a tax-preferred basis from these kinds of accounts. Just as an aside, I still have a question as to why menstrual care products are not considered medical care. Again, amounts paid for the mitigation or treatment of a disease or for the purpose of affecting a function of the body. Isn't a period or a menstrual cycle a function of the body? I assert that it is. Unfortunately, I do not get to dictate or undo years of tax policy, but there's always things we can advocate for. Also, some states are expanding supplemental nutrition assistance program definitions. This is SNAP benefits, or sometimes referred to as food stamps. Many states have taken action, or there are pending efforts to characterize these as essential so that they can also be used being reimbursed or purchased with SNAP benefits. Another tax feature related to menstrual care products is what is known as the tampon tax. The tampon tax is a sales tax on feminine hygiene products due to their status as non-essential. Again, I'm having trouble with this one. According to a Forbes article in May of 2023, it disproportionately impacts low-income women, which I think is obvious. Citing a study by Kotex, the article indicated that 40% of women have financially struggled to purchase period products at some point in their lifetime. Those without access to period products report missing school or work and feeling embarrassed, ashamed, or depressed. The Alliance of Period Supplies, which is a nonprofit, maintains a map of the U.S. illustrating which states have the tax and which do not. And just in May, this May of 2024, South Carolina became the latest state to eliminate the tampon tax. Wisconsin and Missouri, where Lindsey and I sit today, continue to impose a sales tax on these products, but there are several organizations and large retailers that are working to change this in all 50 states. CVS added this statement to their website in October of 2022. CVS will pay applicable sales tax on period products for our customers in several states where we can, including Missouri and Wisconsin. And then in states where they can't by law pay the tax, they won't. So the treatment of menstrual care products under tax law, to me, illustrates the stigma that can surround women's health issues. Each policy change works to reduce that stigma. So I think the effort and the discussion are important to implementing these types of changes. We're running low on time, but I will mention, speaking of stigma, that there are some benefits that employers are starting the discussion around. And one of those is menopausal benefits. According to the Mayo Clinic's website, menopause is when a woman has not had a menstrual cycle for 12 months. But many of the symptoms start well before that and can continue after. Things like insomnia, dry eyes and mouth, emotional changes, and joint pain. Many symptoms that cause regular work habits to be challenging. According to a Mayo Clinic study, which I thought was interesting, the cost to employers of women experiencing these symptoms has a cost of $1.8 billion in lost time annually, and up to $26 billion when added to the additional healthcare costs. So it's certainly catching the eye of employers for not just this financial reasons, but also for out of care for employees. Some of the things that employers are reporting that they are doing are specific paid leave to address symptoms of menopause, expanded hormone therapy and physical therapy coverage under their health plans, counseling from sleep coaches and nutritionists, or virtual care from OB/GYNs who specialize in menopausal treatment. And just so that we have a few minutes to address questions, I do have some information. Another trend that we're starting to see are caregiver benefits. So caregiver in the sense of caring for aging parents, family members, or loved ones. So just a brief word. Lindsey, thank you for doing this today. I also just wanted to thank the Quarles and Brady Health Law Group, who really spearheaded this series of presentations for Women's History Month. A big thank you to them. This has been very fun to participate in, and I thank you. Lindsey, I know I look like you might have some questions directed to you.
Yeah, thank you so much, Sarah. I learned so much from your remarks, and that was really fascinating. We have time for one question, and there's one that I want to make sure we address. There was a question submitted about whether employers are required to adopt a policy addressing their obligations under the PWFA and the PUMP Act. A policy is not required, but a posting is. So you want to make sure you're updating your postings in your break room or other sort of frequently visited place to make sure that you have the required posting for the PWFA and the Pump Act. And I will say that if you have existing policies on accommodations and lactation, you should update them to reflect the requirements under these two laws. For any remaining questions, we can get back to you by email. I just want to say thank you to all of you for joining us today, and we hope you found it worthwhile.